Stop. Don't scroll. I need you to hear this right now because what I'm about to tell you has already cost thousands of people their legal immigration status in the United States. Not criminals, not people who broke any law. People who followed every rule, paid every tax, and still got a letter saying their visa was revoked. And the reason will shock you. The State Department just dropped a major new alert. And if you or anyone in your household has ever received, applied for, or even been connected to certain public benefits in America, your visa could be in serious danger right now. We're talking denial, revocation, and in some cases, deportation proceedings. The worst part, most people had absolutely no idea this was coming. Welcome back to Entry Status USA, the channel that tells you the truth about U.S. immigration. No sugarcoating, no government doublespeak. If you're new here, hit that subscribe button right now because we cover breaking immigration developments that your own attorney might not have flagged yet. Today, we are going deep on one of the most serious policy shifts in recent immigration enforcement history. This State Department alert is not buried in fine print somewhere. Consular officers and USCIS agents are already using it today when reviewing applications, renewals, and the records of existing visa holders. I'm going to break down exactly what it means, who it affects, which programs are now on the federal watch list, and most importantly, what you need to do right now to protect yourself. Stay with me all the way through because the action steps at the end of this video could literally save your immigration status. So, let's get into it. What exactly did the State Department say? The alert expands enforcement of something called the Public Charge Rule. This has existed in U.S. immigration law for over 100 years. But here is what is completely different this time. The scope, the language, and the intensity of enforcement have all shifted in a major way. Under this updated guidance, immigration officers are now being instructed to take a significantly harder look at whether a visa applicant or current visa holder is likely to become or has already become dependent on government assistance. And the list of programs that now trigger serious scrutiny has grown far beyond what most people expect. We are no longer just talking about traditional welfare checks. We are talking about Medicaid, SNAP benefits, what most people call food stamps, Section 8 housing vouchers, supplemental security income, and even certain state-level assistance programs that were previously considered completely off the radar. Here is where it gets even more dangerous. This rule does not just apply at the moment you are applying for a new visa. It can be applied retroactively. That means if you already hold a visa, a work visa, a student visa, even a family-based visa, and you are coming up for renewal, your past history of benefit usage can be pulled up and used against you right now in this review cycle. This is not a hypothetical scare tactic. Immigration attorneys across the country are already reporting a massive spike in cases where routine renewals are being flagged, and applicants are being called in for additional interviews they never expected. Who is actually at risk? Now maybe you're thinking, okay, but this doesn't apply to me. I work. I pay my taxes. I've never really depended on government help. And maybe you're right. But before you move on, I want you to hear about a scenario that is playing out right now across the United States. Picture a family. Mom is on an H-4 visa. Dad is on an H-1B, working in the tech industry, fully employed, doing everything right. During the COVID pandemic, they lost childcare. Hours got cut, and a social worker helped them apply for temporary SNAP benefits just for a few months to get through it. They never gave it a second thought. Fast forward to today. Dad's H-1B renewal lands on the desk of a consular officer who has been fully briefed on this new State Department alert. The SNAP usage shows up in a federal records check. What should have been a completely routine renewal suddenly becomes a formal request for evidence and then a potential denial. That family is not an exception anymore. That is becoming the pattern, and it gets more complicated than that. If you sponsored someone to come to the United States, a parent, a spouse, a sibling, and that person has used public benefits, your own immigration status can be directly implicated. The affidavit of support that you signed is not just a formality on a piece of paper. Under this new enforcement posture, it is an active legal commitment, and violations are being pursued more aggressively than ever before. Now, hold on because I can feel some of you starting to panic. and I want to address that head on. This video is not here to paralyze you with fear. Knowledge is the only weapon that actually works in this system. The people who get hurt are always the ones who didn't know what was coming. You're watching this right now, which already puts you ahead of most people in your situation. But here is something that almost nobody is talking about, and this is where it gets really important. There is a defined list of programs that are explicitly exempt from the public charge determination: emergency Medicaid, school lunch programs for children, foster care assistance, children's health insurance under CHIP, certain vaccination programs, and public health services. These do not count against you. But if you don't know the difference between what is on the exemption list and what is not, you could spend your energy panicking about programs that carry zero risk while completely missing the real dangers that are sitting right in your application file. So here is exactly what you need to do. Take notes on this part because this is where the video pays off. Step 1. Conduct an immediate personal audit. Go back through the last 3 to 5 years and document every government program you or anyone in your household has used, applied for, or even been denied for. Write down the program name, the dates, the amounts involved, and the reason you needed it at the time. This documentation becomes absolutely critical if you ever face questioning from USCIS or a consular officer. You want to walk in with answers, not scramble to remember. Step 2. Understand your specific visa category's exposure level. Not every visa carries the same public charge risk. Immigrant visas and green card applications face the highest level of scrutiny, but non-immigrant visa renewals are now increasingly in the crosshairs too. H-1B, L-1, O-1, F-1, and family-based non-immigrant categories are all on the table right now. The risk level varies by category, but the risk is real across the board. Step 3. And I cannot stress this enough, consult a qualified immigration attorney before your next filing. Not after you receive a denial, not after you get a request for evidence in the mail, before you file anything. A proactive review of your benefits history in the context of your specific visa situation could be the single most important thing you do this year. Step 4. If you are currently receiving benefits that you no longer urgently need, speak with both a benefits counselor and an immigration attorney together. There are completely legal and documented ways to transition off certain programs in a responsible manner that actually demonstrates self-sufficiency, and that documentation can work in your favor, not against you, during a visa review. Now, here is something else that almost no one is covering right now, and I want you to pay close attention to this. This State Department alert does not only affect people already living inside the United States. It has a direct and immediate impact on visa applicants who are currently waiting at U.S. consulates abroad. If you have a family member going through the interview process right now in any country and their household has any benefit history connected to U.S. federal programs, that interview just got significantly more complicated. Consular officers have received updated training on how to probe for benefit usage during visa interviews. The questions being asked have changed, the documents being requested have expanded, and the discretion given to individual officers has increased. We are already seeing reports from interviews in Mexico City, Mumbai, and Manila where applicants were completely blindsided by this new line of questioning. Entry Status USA has already started tracking these consulate-level changes in detail, and we will be publishing a full dedicated breakdown in our very next video. Make sure you are subscribed and have the notification bell turned on so you do not miss that one. Let me leave you with this final thought. The U.S. immigration system has always been complicated, but right now, in this specific moment, the margin for error is smaller than it has ever been in recent history. One undisclosed benefit, one missing detail in a renewal application, one unexpected question in a consular interview that you were not prepared for, and years of building your life in this country can unravel faster than you think. You deserve to know these things before they happen to you, not after. That is exactly why this channel exists. That is exactly what Entry Status USA is here for, to keep you one step ahead of a system that moves fast and does not always give second chances. If this video helped you even a little bit, please hit the like button right now. It takes 1 second and it helps us reach thousands more people who desperately need this information. Drop your questions in the comments below. I personally read every single one, and your question might become the topic of our next video. And if you are not subscribed yet, do it right now. The next alert we cover may be the one that is specifically about your visa category. Do not wait until it is too late. I'll see you in the next one. Next.